Hello everyone, this is Tom Fox. I'm the Compliance Evangelist, and I'd like to welcome you to episode 333 of the FCPA Compliance Report. The FCPA Compliance Report is sponsored by Advanced Compliance Solutions, your one-stop shop for all things compliance related. I'm pleased to announce a new service offering from Advanced Compliance Solutions called the Compliance Alliance. The Compliance Alliance is a three-step program that will provide you and your sales team a background into compliance and the FCPA, so that you can consider how your product or service fits into the needs of a compliance officer. It includes a boot camp around operationalizing your compliance program, sponsorship of a 30-day podcast series, and in-person training. Interested parties should contact Tom Fox at tfox@tfoxlaw.com. Today I have back with me Professor Samuel Buell, and he talks about his recent article he co-authored with Rachel Brewster on the market for global anti-corruption enforcement. It's a really interesting look at how the FCPA enforcement realm developed, and particularly the cases, or rather the areas that issues that arose from overseas that had to come into place to allow the explosion of FCPA enforcement in the middle of the last decade. Also, he takes a very interesting look at the domestic side of things, and then focuses on a part of FCPA enforcement that is often controversial, which is the alleged revolving door. The episode comes in at around 20 minutes. I think you'll find it a fascinating interview. Dr. Buell is Professor Buell is one of the top law professors in this area, and he writes and thinks about white-collar law quite a bit. This is Tom Fox. Thank you very much for joining me of this episode of the FCPA Compliance Report. Hello, everyone. This is Tom Fox, back for another episode of the FCPA Compliance Report. Today, I am extraordinarily pleased to have back with me Professor Samuel Buell. He is the Bernard M. Fishman Professor of Law at Duke University, and he, along with his colleague Rachel Brewster, have recently published a new paper entitled The Market for Global AntiCorruption Enforcement, which is available at the Duke Law School website, which I will link to in the show notes. So with that somewhat long-winded introduction, Professor Buell, welcome back, and looking forward to a discussion of your article today.
Hi, Tom.
So could you tell us maybe what led you and Rachel to put your heads together to put this article together?
Well, we've been each teaching in our different areas. You know, I teach white-collar crime, corporate crime, and ordinary criminal law at Duke, and Rachel teaches international financial regulation and global commercial law. And I've long been interested in the FCPA, obviously, as is everyone who teaches in my areas. Rachel had become interested in the FCPA in the last couple of years. And so we began talking about it. Rachel started teaching a seminar on it at Duke. She came to my course a couple times, and we sort of co-taught classes. And so I guess it was sort of inevitable that we would write something together at some point. But then a couple of members of our faculty organized a year-long series of workshops that culminated in a symposium issue of our wonderful journal, Law and Contemporary Problems. And the theme of that project was law and markets. And they asked us, would you guys like to do something for this? And Rachel and I each were asked individually. And then Rachel and I talked and said, well, maybe this is where we should do the FCPA paper. And we can center it around the idea of that there's been this kind of market for enforcement globally that's developed over the last few decades. And maybe there's been an absence of a kind of big picture overarching piece to explain, how it came to pass that in this enforcement market where in theory jurisdictions would compete, the U.S. has dominated.
So the article has broken down generally into both first an international sphere and then a domestic component. In the international, what I was most interested in was y'all's, if I can use that good Southern plural possessive of y'all's discussion of the various strands of international thought, international leadership by the United States, and frankly, international spade work by the United States to bring corruption to the forefront, tied together with various economists who came to view corruption as a very negative impact on emerging economies. And that sort of leading up to about the year 2000 poised the domestic market to have many avenues open and bases for investigation and enforcement action. So I was wondering if you could walk us through the changes in the international scene, sort of from the passage of the FCPA, maybe up to around 2000.
Yeah, so this is really, not surprisingly, Rachel's part of the paper. She's the international law expert, but I learned a lot from her in writing this paper together, and it's just such an interesting story about how kind of law and norms interact on the international stage in ways that can lead to real changes in doctrine and enforcement on the ground. So, of course, it's well known by people who practice in the FCPA area that the FCPA, as you well know, Tom, was originally enacted to deal with concerns really about domestic political corruption more than anything, and its sort of tentacles abroad, and came after Watergate, and it really wasn't a statute that was designed initially to engage other countries in a discussion about what the norms ought to be around bribery and corruption. And in fact, at that time in the 70s, there were not strong international norms against bribery and corruption. The famous fact that a lot of people know is that at that time in Germany and some other European countries, bribery could be deducted on a corporate tax return. I think the attitude was cost of doing business in the developing world. On balance, it's better to pay the bribes and get not to, because everybody benefits from development, and the international institutions like the OECD and the World Bank that might have had something contrary to say about that were to some extent bought into that thinking. That just sort of what the intellectual landscape was, and those institutions those kinds of international institutions can be very shaped in what they do by what the dominant wasn't a lot of worry about corruption. Something shifted post FCPA enactment, in the 80s and moving into the 90s. And maybe it has to do with globalization. Maybe it has to do with, the internationalization of commerce, technology, a level of visibility and transparency around the world about what was going on. And there was this, appreciation that developed within the international institutions and also spurred on by a change in attitude among academics that corruption was a real drag on development. Aside from all the human rights and other issues that are associated with separate and apart from anything that the U.S. was really doing. I mean, the U.S. was involved in those institutions and was anti-corruption in the positions that it took, but it really required an international shift before the U.S. was really in a position to develop what has become the modern FCPA practice, because these are international cases. And even if you have a law, it's very hard to enforce that law abroad without some buy-in from other countries, or you're going to find massive obstacles to being able to collect evidence and bring cases.
So one of the points that really intrigued me was sort of on a parallel track, but really separate and apart from U.S. efforts, was the World Bank and World Bank policymakers, and they came to this sort of change in economic thinking, but it was more than just academicians thinking, or policymakers rather thinking, that there were a group of economists who left the World Bank to form Transparency International, a well-known NGO focusing on increasing government transparency as a mean of decreasing production. So you had these various disparate strands all moving forward, together with the U.S. really leading efforts, as you said, to try to overcome the lack of foreign support for domestic law. So they were able to create this foreign support through the OECD, which you guys point out may not have been the obvious choice to utilize as a mechanism. Nevertheless, the OECD became an essential part of opening the door to greater enforcement of the FCPA, but it's still, that leaves open the domestic side of things. And so I was wondering if you could turn to your section entitled A Domestic Industry Grows and explain sort of the top down and then bottom up, and most particularly the control rule and how the U.S. Attorney's Manual really fits into this in a way that many of us may not have understood.
Yeah, so I think, again, sort of by happenstance, not because, this shift in international attitudes was necessarily anticipated or foreseen, but institutionally in the FCPA, the DOJ, at some point after its enactment, built in these kind of procedural dimensions to it that don't exist with regard to other federal criminal statutes, or only with respect to a few of them. And that was the mandate of main justice approval for FCPA prosecutions. And the original worry that gave rise to that was, these are going to have foreign policy implications. And so we need sort of the political leadership at the department to be looped in when prosecutors are doing these cases, because there might be reasons they need to consult with the State Department or worry about collateral effects that a prosecution could have on other U.S. interests outside the criminal law. I don't think that was a position that was developed because they anticipated a huge volume of FCPA prosecutions. I think they just looked at the statute and saw this as a particular kind of foreign policy related criminal law. And so they put those procedures in, and then they needed a place in the DOJ for that review process to take place. And it was assigned to the fraud section, which is not just a supervisory part of the bureaucracy, but an actual enforcement office in main justice that has lawyers that bring cases. So you had a place for FCPA cases to land so that when the doors opened internationally, there was a cadre of prosecutors who were available to do those cases out of main justice, and almost would have jumped on an opportunity to have a set of cases that they could focus on that would justify their existence in the way that bureaucrats do. So the path opens internationally. There are structures in place domestically for these cases to be brought. And then, as often happens with these federal criminal statutes, another example would be healthcare fraud enforcement. If you went back 20 years, have to bring cases. Suddenly there is sort of discovered on the books the statute that, hey, these cases look like they're actually pretty straightforward. There, so let's start doing them.
So from the structural part of the international side, moving forward to the domestic side, could you now speak to sort of what you call the bottom-up approach?
Yeah, so I think, you have these institutions in place in DOJ. You have the pathways opened internationally. And then you have the question of sort of how do federal prosecutors decide what they want to do when they have limited resources, but also they have um, completely open jurisdiction to choose what they want to spend their time on. They have a discretionary docket. So what is it about FCPA cases that becomes attractive? And again, I think, you often have these stories in federal criminal law where one or two or a few prosecutors or one office kind of discovers a largely dormant statute and sees the ability to make a bunch of cases because they're, essentially reading about what's going on out there in markets, and there's a problem and there's a statute that fits, and U.S. policy is behind it. And I also think that, bribery, which is the core of the FCPA violation, is something that any prosecutor who's been trained in any kind of criminal enforcement is probably going to immediately recognize as kind of a clear-cut form of wrongdoing. I know what this is. I know it's wrong, and I know how to prove it. It's not maybe as murky as something else might be, like accounting fraud or insider trading. There aren't as many gray areas. It's just a question of which cases we want to do and how hard is it going to be for us to get the evidence to prove them. And, as markets are globalizing and U.S. corporations are operating more and more fluidly abroad, there are just going to be more of these situations popping up that prosecutors are going to see and say, hey, well, why don't we do a case about that? And, it's a nice black and white story. It has the case I'm looking at is clearly wrongdoing, and it's got a policy justification behind it, which is, if we can do something, even a little bit about this corruption and bribery problem, maybe we're helping people in the world. And maybe we're even helping level the playing field a little bit for U.S. corporations. So it could be kind of a win-win. And I think federal prosecutors, because they have this discretionary docket and they can only do so many cases, they like to think the ones that they do pursue are having a public policy impact.
So that's really a great last point. But if I could change the focus just a little bit, which is I really now saw in your article kind of a market response, which was that prosecutors developed a tool at some point in the late 1990s or early 2000s of the Deferred Prosecution Agreement, and that's probably not even right. I'm sure it was around long before that, but they started utilizing it. And then law firms began to hire or utilize prosecutors to do more rigorous and robust external investigations for corporations and negotiate penalties with the prosecutors. So it seemed to me to be sort of driven by the factors you've articulated, but then the market responded to the direction the government went. Is that something close to what you guys were trying to say?
Yeah, exactly. And I think that, when we put together explanatory stories like this as academics, we often use the word overdetermined, and the explosion of the FCPA practice is overdetermined. These various causes intersect in a way that collectively make it much more likely to have ended up where we are than if there had been only one or even two of them, right? So this other cause that you've just identified is kind of, once there's a pump of cases into the government, that pump has to sort of stay primed for the prosecutors to continue to do these cases, and there to continue to be hiring around the fraud section offices and policy initiatives in this area and so on. And perhaps somewhat ironically, the defense bar becomes the primary source for priming that pump. And so here what we have is the FCPA story interacting with the larger story that I think we're all familiar with now about the development of corporate crime prosecution in general since the Clinton administration, and the Holder memo, the Thompson memo, the Phillip memo, the Yates memo, and so on, the government's very self-conscious effort to set out a kind of enforcement program for corporate crime that trades off corporate criminal liability against cooperation. And for companies to engage with that enforcement program in any meaningful way, they've got to have, these big law firm operations that can do the investigation and then do the negotiating with the government. And if the law or the settlement market is set up in such a way that the major thing that you get credit for is self-reporting, then there's going to start to be cases actually just being brought to the government by corporations, not even the prosecutors going out to look at them. And then it becomes kind of a, as I said, a pump that just keeps flowing. And it's very interesting to see that even the new administration, Sessions and others, have made comments in the last month to suggest that the government may continue to just do these cases, and the market will continue to flow.
Next, if I could turn to what I found, what I have to believe was really personal writing from you, but in the context of the article, you directly took on the concept of the revolving door. And what I found most interesting about it was an articulation to show that it's really a false construct. I have argued that the protections in place for lawyers who leave the Department of Justice in terms of length of time before they can negotiate with their former colleagues is enough. But you go at it a completely different way and explain why it is really a false construct. So I was wondering if you just might be able to touch on that, because I found it quite frankly so powerful.
Well, I think I, first of all, felt like I had to address it in this account that we've been going through, because once you get to the point where you talk about the defense bar's involvement in sort of contributing to the flow of cases into the government and how that explains, in part, the explosion in FCPA practice, I think some people will naturally react to that by thinking, oh, well, that doesn't look good. That's just, so this whole thing of FCPA enforcement is just a full employment act for prosecutors and defense lawyers. They're kind of giving each other cases. And then if it turns out that the prosecutors go to work at the big firms, which is very much true, then it looks like, this isn't really a public regarding exercise. It's an exercise that's designed to create a market for legal services. And I just don't think it really works that way, because the kind of people who go into federal prosecution service are all people who've either already got or could easily get well-paying jobs at big law firms. Yes, the government service adds to your resume, and maybe it helps you make partner down the road, but it might be in some firms safer to make partner by staying. So, but in any event, I mean, the kind of people who do this job do it because they want the autonomy, the public interest motivations, the opportunity to maybe make an impact. And so I don't think it's the case that they go into the government, they start doing these kinds of cases, and then the first thing that's on their mind is, well, what does the defense bar want me to do? Because I want to get hired by them later. But it's understandable to me that people would, possibly perceive it that way, because the fact that most of these cases settle and then the negotiations occur between prosecutors and defense lawyers who are former prosecutors makes it seem a little clubby. But I think what's really going on in that club is that those lawyers are working out together a shared set of norms, almost a common law, if you like, for how these cases ought to be settled. What should the sanctions be? What kind of monitoring and reform provisions ought to be put in these settlements? What should companies be required to do? And they're trying, as anybody does in the settlement context there, to strike a balance between a penalty that's going to have a deterrent effect, but the ability of the corporation to continue to do business and hopefully to do business in a more law-abiding manner. So I think what's going on there more than sort of let's create work for lawyers is let's figure out a way to be good policy lawyers who have an impact on markets in a way that's productive and promotes compliance with law, but doesn't create unnecessary harm. Now, it's quite fair, I think, and appropriate, as many academics have been doing, to criticize whether those lawyers are actually getting to the right result. But what I'm really talking about is, I think, better understanding kind of what they're up to and what their motives are.
So I'm visiting today and have been visiting with Professor Samuel Buell, professor of law at Professor at Duke Law School, on his article that he co-wrote with Rachel Brewster, The Market for Global AntiCorruption Enforcement. I would certainly commend it to anyone who is interested in how the FCPA developed, particularly how anti-corruption enforcement developed. And as always, a great read, fascinating story. And Professor, I look forward to your next piece, whatever that might be.
All right. Thanks, Tom.
This is Tom Fox again. I'd like to thank you for listening to this episode of the FCPA Compliance Report. If you have listened to this podcast on iTunes, I would greatly appreciate it if you would rate our podcast, as it would help in our rankings and also help get the word out about the top-rated podcast in compliance and compliance-related issues. Also, if you have any questions, please feel free to contact me at tfox@tfoxlaw.com. This is Tom Fox. Thanks again for listening to this episode, and I hope you'll join me again for another episode of the FCPA Compliance Report.